relating to the evidence adduced and ingredients to be proved in each case. The burden of proof in a criminal case is always reasonable doubt. Is always beyond reasonable doubt, and it lies on the prosecution. See Sektoreko versus Uganda of 1967, East Africa, 531, Miller versus Minister of Pension of 1947, 2, All England Report, Volume 272, page 373, and Wellington versus DPP of 1935, Appeal Court 462. This court also addressed its mind to the fact that an accused should only be convicted based on the strength of the prosecution evidence, but not on the weaknesses in accused defense after evaluating all the evidence as a whole. Before this court applies the above laws to the fact of determining the issues in this case, we have addressed our mind to the fact that the counsel for the accused person in his submissions before this court submitted that CCTV footage from the hotel and a ballistic expert were never produced in evidence. This court took note of the counsel's application to bring the CCTV footage. This court took note of counsel's application to bring the CCTV footage which he claimed he had in possession at the appropriate time during the trial, but not as preliminary objection to hold a criminal trial. When the accused were put on their defense, he never produced the said footages. Furthermore, the prosecution in the entire trial did not rely on intimate that the CCTV cameras were at Vine T Hotel and the room where A1 was arrested from. This court agrees with the counsel for the state that he who alleges the existence of any fact must prove it has, as per Section 101 Evidence Act, Cap 6. On the issue of ballistic expert, this court is composed of highly experienced military officers who have the capability to know whether the gun before court and ammunition are real or not. This court now turns to apply the law to the facts as found and determination of the issue raised. In count 3 and 5, this court has considered the evidence of prosecution witness 1, Private Sakaija Richard, and prosecution witness 3, Major David Agaba, and it is satisfied that all the ingredients of the offense have been proved beyond reasonable doubt against Haji Kitatta Abdallah after weighing their evidence with that of the defense as a whole. In count 1 and 4, this court has considered the evidence of prosecution witness 1, Private Sakaija Richard, prosecution witness 3, Major David Agaba, and prosecution witness 4, Kopolo Baguma Alex, and is satisfied the ingredients of the offense have been proved beyond reasonable doubt against Ngobi Sowale after weighing their evidence with that of the defense as a whole. In count 2, this court has evaluated all the evidence adduced in court and is satisfied that pistol registration number UGPOL 00753421383, was lawfully issued to Ngombi Sowale for official duties, and therefore the prosecutions have not discharged the burden of proof on all ingredients of the offense. Evidence of defense witness 11, SSP Nixon Agarugaba Karuhanga Agazire, was credible and reliable, since he told court that he is the one who ordered Ngombi Sowale be armed with a pistol in issue for official duties use. In count 6, this court has evaluated all evidence before it, applied the law to the facts, and finds that the prosecution has not discharged the burden of proof as required by law against A1 to A10. In premises, deliberations in this court pronounce itself as follows. 1. In count 3, Haji Kitatta Abdallah is found guilty of the offense of unlawful possession of firearms, contrary to Section 3, subsection 1, subsection 2, para A of the Firearms Act, Cap 299, as charged. 2. In count 5, Haji Kitatta Abdallah is found guilty of the offense of unlawful possession of firearms, contrary to Section 3, subsection 1 and subsection 2, para A of the Firearms Act, Cap 299, as charged. 3. In count 1, Detective Constable number 42991 Ngombi Sowale is found guilty of the offense of unlawful possession of firearms, contrary to Section 3, subsection 1, subsection 2, para A of the Firearms Act, Cap 299, as charged. This court further finds Haji Kitatta Abdallah and Sekaja Ibrahim not guilty of the offense in this count. 4. In count 4, Detective Constable 42991 Ngombi Sowale is found guilty of the offense of unlawful possession of firearms, contrary to Section 3, subsection 1 and subsection 2, para A of the Firearms Act, Cap 299, as charged. This court further finds Haji Kitatta Abdallah and Sekaja Ibrahim not guilty of the charges in this count. 5. In count 2, the accused person, namely Haji Kitatta Abdallah, Detective Constable Ngombi Sowale, and Sekaja Ibrahim, are found guilty of the offense of unlawful possession of firearms, contrary to Section 3, subsection 1 and subsection 2, para A of the Firearms Act, Cap 299, as charged. 6. In count 6, the accused person, that's Haji Kitatta Abdallah, Kibrija Joel, Senfuka Matia, Sebata Hassan, Sebandeke John, Mugemba Hussein, Tunomunjini Amon, Bwanika Fred, Ngombi Sowale, Sekaja Ibrahim, are found not guilty of the offense of unlawful possession of military stores, contrary to Section 160, subsection 2, para C of Uganda Police Act, Cap Act 2005. In conclusion, this court finds as follows. 1. A1. Gibrija